people start to join, we will get started. Thank you for zooming in today with us. On behalf of the Sandbox Center team, welcome to our Experts in Residence session, The Legal Brief with Barriston Law. For those who haven't been acquainted with me or the Sandbox, I'm Mackenzie. I'm one of the 5 members of the Sandbox team. We're located downtown Barrie and now online to connect people and their ideas to business resources on their journey to success. So if you haven't attended one of our recently launched Experts in Residence sessions prior to this, we're happy to have you with us. Across a wide variety of different expertise, we're offering free expert advice to all businesses across the region in order just to help support with the economic impact that COVID-19 has created. So if you're interested in learning more about what our Experts in Residence program has to offer, you can head over to our website, sandboxcenter.com, after this session and check it out under the Programs tab. So today, we're thrilled to have expert Janice Mumberson from Barriston Law join us to discuss commercial leasing tips and traps and answer any burning questions you may have as it relates to rent relief and more. There's so much going on in regards to COVID, so we're so happy to have Janice here today. Please use the Q&A feature at the bottom of this screen. We'll be monitoring this throughout, and if you have any questions come across your mind, just quickly pop it in there and we'll try to get to answering as many of your questions as possible. Just a quick thank you to all of our community partners for supporting with the sharing of our events, and of course a huge thank you to our sponsor Barriston Law for delivering today's session. So without further ado, we can get this show on the road. Janice, I'll give you the floor to start us off.
Thanks so much, Mackenzie. It's a pleasure to be here. It's always really enjoyable, and I'm looking forward to answering any questions or as many questions as I can today. So please, to anyone out there who's watching, don't feel shy with the comments and questions. I may not be able to answer all of your questions, but I am happy to follow up with you as well. So we have a PowerPoint presentation that Mackenzie's just projected onto the screen, and my email address is right there, and I imagine, Mackenzie, that it will be circulated or available if anyone has any questions.
Absolutely. We'll be sending out this presentation as a recording afterwards. We'll be posting it as a blog on our website. So for those who missed today's session, don't worry, we got your back.
Awesome. Thanks so much, Mackenzie. So Mackenzie, if you can flip to the next slide. So as Mackenzie spoke about, right now, times are really unprecedented in the commercial tenancy market in Barrie, in Ontario, really everywhere. So summer 2020 is a really unusual time for commercial tenants and landlords. And so today I'm here just to talk a little bit about what's going on with Ontario legislation and maybe just share some information and maybe some stories that hopefully will be of help to the audience. So just a quick disclaimer, this presentation does not constitute legal advice. To have that, you've got to meet your lawyer face to face and they've got to know the specifics about your individual situation. But it is, I hope, helpful information for you to have in the back of your mind when you're going forward. So we're on to the next, the fundamentals of commercial leasing. So I think most people watching will know this, but at its core, a commercial tenancy relationship is a contractual relationship. So all that means is that a tenant and a landlord are both considered to be savvy individuals by the government and by the common law system under which Ontario laws operate. And so they come to an agreement about what their relationship's going to look like and what rights and obligations each is going to have to each other. So unlike residential tenancies, where oftentimes the courts will assume that a landlord has a little bit more sophistication than a tenant, commercial tenancies, the courts do tend to assume that both parties have equal negotiation rights. Sometimes that's not always the case, of course, but that's the default position of the courts. And in particular, unless it's a situation where one party or the other just shoves across the table a completely finished tenancy agreement or lease and has the other person sign it without an opportunity to review it with legal counsel, the court will assume that both parties have turned their minds to that commercial lease agreement, which is why it's so important that that people are really comfortable with the provisions in their lease. And it's why when things like COVID-19 or a pandemic hit, it's really a time to kind of take stock of the provisions in your commercial lease or make notes to yourself so that in the future, when you're entering into new commercial leases, you can sort of have these little cliff notes about, okay, why did I think this provision might be important in a situation like this one? or if something similar ever happened again. So just like COVID-19 kind of came in hard, well, what happens then once you've got this commercial agreement that you thought was perfect, and then something that was completely unanticipated happens? So Mackenzie, I'll get you to flip to the next slide. So with COVID-19, everything really shook up the commercial tenancy and commercial leasing environment. So of course, on March 17th, the Government of Ontario declared a state of emergency. And then on May 25th, the federal government announced plans for the Canadian Emergency Commercial Rent Assistance Program, or CECRA. So this was the plan that I'm sure many of the audience have some experience with. But basically what this meant was the federal government offered to pay 25% of the commercial rent to landlords. The provincial government offered to pay 25%. The tenants still had to remain responsible in paying 25%. And then the landlord was asked to forgive 25% of the rent. There were quite a few different conditions as to who was eligible to receive this benefit. But at its heart, the Canadian Emergency Commercial Rent Assistance Program was meant to help commercial tenants keep their spaces and keep their leases in good standing, and was intended to help ensure that commercial landlords who weren't going to be able to collect rent from tenants were at least able to get some relief. So what this meant was we did have quite a few landlords and tenants take advantage of this benefit being offered, but everything was so unprecedented that many landlords weren't sure that this was a really great solution for them. So many didn't know if they should hop on the train right away and submit their application, or if they should wait to see what other rent assistance might come. And then the government took additional steps June 18th with the Protecting Small Business Act to really encourage commercial landlords to apply for the CECRA benefit. The rationale being that benefit had to be applied for by the landlord, and many landlords didn't want to apply for it because they did waive certain rights and say that they wouldn't terminate the lease or kick the tenant out for non-payment of rent, provided they were making that 25% payment during the times they were receiving the benefit. So the government took action, and on June 18th introduced the Protecting Small Business Act. And basically what it did was it got rid of almost all of the enforcement options that landlords had under commercial leases, especially if it was for termination for non-payment of rent, unless the landlord could show and demonstrate that they had applied for the CECRA benefit. So there's all sorts of intricacies to that Protecting Small Business Act, but overall its goal was to really encourage landlords and tenants to work together and to apply for that CECRA benefit. And then of course, June 30th, so the benefit was only supposed to go for the months of April, May, and June. And then on June 30th, the finance minister announced that they were actually extending it into the month of July. So now anyone who has entered into a CECRA agreement, they are receiving that benefit from the federal and provincial governments through the month of July and to the end of July. So Mackenzie, I'll have you flip to the next slide. So with all of this happening in the environment of commercial leasing in Ontario, the results on the commercial leasing market have been fairly significant. Certainly from the landlord's perspective and from the tenant's perspective, there's just a whole new web and list of factors to consider when they're not only enforcing existing rental agreements, but also thinking about potential extensions or potential new leasing arrangements with a new landlord or a new tenant. So what we saw with existing relationships where there was already a lease that was entered into prior to the declaration of the state of emergency, were many tenants and landlords seeking to amend the terms of the lease agreement. So sometimes this was because the landlord knew that the tenant was a great tenant, but that they would struggle to pay even 25% of the rent. So sometimes the parties were agreeing to do things like defer a bit of the rent to a later date. And this worked in certain situations, but it never worked where it was one party trying to say, this is what has to happen. Obviously, from both the landlord and the tenant perspective, there are challenges associated with just deferring rent. It's ultimately payable later on. But we did see amending agreements, and not just for rent. We saw amending agreements where landlords allowed their tenants to use the premises for a slightly different business model. Certainly businesses that required more face-to-face with customers had to really think on their feet and pivot or rotate if they could into a different service model. So being able to amend use provisions. So for example, if you used to be an eat-in restaurant only and weren't allowed to offer takeout services, often the landlord and the tenant would agree to amend that use provision to allow the tenant to offer takeout or even delivery services from the location. Now, the other result was we did see quite a bit of communication open up between landlords and tenants, not only during discussions about the CECRA benefit, but about potential amendment agreements for the lease. We also saw the delay of enforcement. So many landlords chose to not do much. They may have chosen not to amend an agreement or to put in an application, but just to make sure that they were still kind of keeping their tenants and then sort of taking stock of their options to enforce. And that's something that we'll speak a little bit more about with the Protecting Small Business Act right now. You cannot enforce a lease right now, and we're not sure for how long that is going to last. Eventually, either a landlord would apply for the CECRA benefit, or the Protecting Small Business Act will end eventually, and if the tenant default continues past a certain period of time, the landlord will be able to take the traditional steps they have to enforce a lease. What remains to be seen is whether the courts will interpret COVID-19 or a pandemic or a declaration of a state of emergency as being an event that was so wholly outside the realm of what the landlord or tenant could have or should have considered, that the court would deem it to be something that would fall under what's called a force majeure provision. Now, there's a lot of discussion about this and quite a bit written about it. And the common thought seems to be that the courts will not take this to be an event of force majeure. What that means is that tenants who may be hoping that the courts would be more sympathetic to their default that occurred during the COVID-19 pandemic, that may not be the case. And the courts may just say, unfortunately, you still had the obligation to pay your rent in accordance with the lease. And so there may not be quite a lot of forgiveness there. Now, when we're talking about lease enforcement, it's incredibly nuanced. The landlord, of course, has the obligation as well to mitigate its damages. It's tough to do that right now when not a ton of new businesses are opening up and eager to sign on to leases, especially with the same terms that might have been in a lease entered into pre-COVID times. So it might actually be quite difficult for a landlord to mitigate their damages if a tenant was defaulting. So those are some intricacies that we can talk about. If anyone has any questions in particular about those, I'm happy to try and address them as best I can, or to arrange for you to connect with someone who's able to assist. Some of the other things that we saw as a result of COVID was new discussions happening during the negotiation point. So there are, of course, still businesses that are looking to enter into commercial leases, either for businesses opening up in the next few months or even 6 months out. But obviously everyone now has different considerations. And so there are a lovely number of provisions in a commercial lease. Anyone who's entered into one knows that they can be anywhere from 5 pages to 50 plus pages. There are a ton of different provisions that are up for discussion between landlords and tenants. There are things like fixturing and whether the landlord contributes to any fixturing, or any tenant allowances where they actually help fit the interior of a business, and then they actually amortize it over a certain amount of time and it gets built into the rent so that the landlord ultimately gets their money back, but the tenant doesn't have that large out-of-pocket expense up front. That is certainly something that small businesses may be looking for, and it may be something that landlords are willing to offer, given that it could be quite difficult to attract long-term tenants in the coming months or even the coming year. The other thing we're seeing, of course, is that tenants are going to be a little bit more aggressive about ensuring that they've got a broad use provision in their lease agreement. And this is particularly where a tenant is entering into a lease for a premises that's located in a larger center setting, where the landlord may have other restrictive uses or certain covenants that they've guaranteed to, let's say, I seem to be relying on restaurants a lot as examples, but for example, if you have one really large chain coffee takeaway center the landlord may insist or try to insist on restricting any other coffee or restaurant even, their use provision, and say that they're specifically not allowed to sell any hot beverage or coffee or tea for takeout. That may not have been a problem in the past, where maybe you had a dessert restaurant or something like that that also served coffee or tea on the side. But I think the way that business is now being conducted has shifted substantially, and people are relying more on call in, order, pick up, takeout, those kinds of service models. And so certainly that's something that tenants will want to watch. You're going to want to pay attention to that use provision. And from a landlord's perspective, you are as well, because you want to make sure that if something happened and your tenant had to pivot or change the way they did business, that they're able to do that without the landlord going back and making amendments to a commercial lease agreement. So that's certainly a few of the provisions that you'd want to take a good look at. The other kinds of things that you might want to consider, of course, both sides will be looking to limit their risk and exposure. So it's really difficult to say that, oh, you just build in a provision that says, in the case of a declaration of emergency or in the event of a pandemic, the lease just terminates and the tenant can walk. There are very few landlords that are going to allow for that provision, because of course they have this property, they have the overhead, they have to pay property taxes, and they're going to need to have a reliable source of income for that property. And take into consideration the CECRA legislation, that benefit is only available to landlords if there's a lease in good standing. So as much as both parties are looking to limit their exposure to risk, both parties are of course going to have to consent to the agreement, and ultimately that will come down to negotiation power. So what we'll see in the next few months is whether there is all of a sudden a shortage of tenants looking for commercial space, in which case we might find that landlords are more willing to take on more risk to get a good tenant, or whether there actually isn't that huge missing tenancy population, and maybe things won't loosen up as much. I think what we might see are landlords who are much more cautious upfront about doing credit checks, and they may be asking for more advanced rent or security as a down payment. And that might be where the landlords and tenants can find room to negotiate, is in these security deposit payments, as well as in things like sort of shortened liquidated damages periods. So often really complex commercial leases will have a provision that says that in the event of a default, the next 3 months of rent are immediately due and payable. Now that doesn't get rid of the landlord's ability to collect for the remainder of the term, but it does get them some cash upfront right away that they know that they are entitled to. And then at least with that in the back of their minds, knowing that they can ultimately collect that, they can go out and they can look for a new tenant to help mitigate their damages. So those are the kinds of provisions where you might find some room for negotiation. And then similarly, I think the right to negotiate or assign or sublet a premises would be important as well. Because one thing that we did see through this was it was very sector specific in terms of the businesses that felt the impact of COVID right away. But there were other businesses that actually did quite well through COVID, who may have actually been looking for more space, and the ability of a tenant to enter into a short-term license or sublease agreement might be a creative solution that actually helps offset the tenant's costs, provide additional space to a business that's maybe looking for it, but ultimately still provides the landlord with some control and protection about who's using the space during a potential flare-up or second wave. Now, I see that we've got some comments popping up in the Q&A. Mackenzie, would you mind reading out any of those?
Yeah, definitely. So
Awesome.
we have about, is email correspondence good enough in adjusting the provisions of the lease, such as expanding the use provisions, or is a formal amendment necessary?
That's it. Okay, so that's a great question. And this applies across all types of contracts. So when we're talking about land, it has to be in writing, and email is considered writing. So one thing though that I would suggest is that you want that email the ultimate result of the negotiations to be as clear as possible. And so that's where you may want to consult with a lawyer just to make sure that it says everything it needs to say. The risk you run is that if you've got a chain of emails where you've gone back and forth over the course of days, weeks, or months, if ultimately you were trying to show what the actual end agreement was between parties, if you present that to a court and say, well, here's the email, and then the other side says, well, here's the thread of the emails, and you can see where we went back and forth, and maybe it was unclear because I thought that, you know, this term from 5 emails ago was still part of the end deal, even though this one only discussed use. I thought it also talked about the fact that we were delaying rent and I wasn't forgiving it. So email is a written agreement. It is enforceable, but is it easy to enforce and is it clear on its face? That's really the important question. So for example, I think an email is quite a good way of saying, all right, we agree to reduce the basic rent or the per square foot rent from $6 to $4 per square foot for the next 2 months. After that, you return to $6 per square foot. I think something like that, that's so simple, could be quite easily done. Similarly, a use provision, I suspect could actually be quite easily done. I would recommend though that you just make it as crystal clear as possible and that you make sure that the email responses are coming from the specific email address or are signed by somebody who has the authority to bind the corporation. On most contracts that you see, underneath the signing line, where someone is signing on behalf of a corporation, it will actually say, I or we have the authority to bind the corporation. And that's so important because, of course, a corporation is a separate entity from a person, and it might have 5 or 6 different officers or directors or people with signing authority. So when they're signing on behalf of the corporation, so for example, you would never argue that a contract signed by a teenager working part-time at a Dairy Queen is binding on the whole corporation. But how do you know who has signing authority for Dairy Queen? It's somebody who holds themselves out as having signing authority. It's somebody who has demonstrated to you that they have the authority where it's likely that they would have the ability to bind the corporation. And then, of course, past history matters. So if the person who's responding to your emails, you know, is the person who maybe they're the principal, maybe they're the sole shareholder of the business, and even though a building is registered in the name of the corporation, it's really this guy, let's say Bob, who owns the building, and Bob's the guy you're emailing with, that's probably okay. But if it's Bob's son or daughter that's never really had much to do in the past with administering the leases, then that's a little bit tricky to say that it was enforceable against Bob's company. So email certainly is really effective. And then I do think that the kind of gold standard is just to take whatever's in that email, put it in a little Microsoft Word document, and then actually have the parties sign it and look to the signing line in your lease if you need to know how to set that up. But I do strongly recommend that wherever you're starting to amend the terms of a lease, particularly if it's a long-term lease, I think it's a good idea just to have a lawyer take a second look at it. It doesn't necessarily mean that they have to run the full file or even draft it, but they might have some really good insights as to things that should be included in that written agreement. Okay, hopefully that answers that question.
That was great. One more before we continue. I know we have other questions, but we could probably get to these at the end. This is kind of just as you were speaking. Do you have a template or draft letter / proposal for tenants to use in approaching a landlord to apply for the CECRA relief?
I'm so glad that the answer is yes. Yes, we do. So Barriston has a really terrific bank of blog entries on every possible legal topic that you can imagine, except criminal law. We're full service, but we do not practice criminal law. But we do have a blog entry that is specific to the CECRA programming. And there is a template letter that you can download and you can use, and it's available directly from our website. And so if you Google Barriston blogs, it'll bring up a whole list of them, and look for the specific blog entry on the Canadian Emergency Commercial Rent Assistance, and it will be right at the bottom. There's a link, and then the actual CMHC, who's administering the benefit program, also has a form. So you can look to the Barriston for the local template, or you can go to CMHC as well.
Perfect. And I can provide definitely in the follow-up with all the registrants resources to Barriston's blog entries as well.
Yeah, that would be great. And we have a more recent entry as well on the Protecting Small Business Act. So for anyone who's looking to just have a little bit more information about those two pieces of legislation, hopefully they're very good reads. I'm a little bit biased. I wrote them, but hopefully there's some good information in there.
Awesome. So you can continue if you'd like, Janice.
Sure, absolutely. Okay, so we were talking about, so actually our next slide is entering into a new lease. And so this is where there are quite a few people now who are either coming up to a renewal term or who may be considering entering into a new lease. So I think the most important thing for tenants and landlords, as I was sort of touching on before, is to really get creative. Tenants and landlords will be looking to share the risk of potential future pandemics or shutdowns. And so I think it's really important for both parties to ensure that they know what's most important to them. So if for a landlord, it's most important to know that they've got cash flow 3 months out, they may be looking for a heftier security deposit. But if what they're thinking is, I want a tenant that has an established history as a business that's operating, they may be willing to take a little less rent up front. And then in the renewal terms, actually have a little bit higher of a base rent. So those are all things that, sorry, I think I cut out there. But those are things that should be considered. So those are things that should be considered when you're looking at entering into a new lease. But also consider fixturing. So I touched on before, are there certain impediments to a small business who's getting up and running in terms of the cost of putting in a new counter that perhaps a landlord is able to assist them with, and then they can offset that initial cost by just increasing the rent, maybe a little bit over time, but that allows the tenant to maintain some cash, which is really helpful when cash flow is a little bit more erratic. So tenant allowance is what this is typically called. So that's something that you can certainly consider when you're heading into a new leasing agreement. And then I have also said, consider whether a declaration of emergency should be added into a force majeure provision, or perhaps it's a triggering event that results in a different rent rate. So for example, if you're a restaurant or a bar or wanting to start one, and you have a really understanding landlord, or you have a landlord that's just really concerned that they're going to have an empty space unless they're flexible with their tenants, maybe do say that if ever the provincial government or federal government declares a state of emergency, that rent is either delayed or reduced to a certain amount of rent, but that the lease still continues on. It's impossible to know everything that the future holds. COVID-19 has proven that, but we have this experience to learn from. And so I would suggest to anybody, especially if you're a brand new business, talk to people who are in a similar industry and get to know what their challenges were with their lease during this particular time period. And you'll probably learn a ton about that. And then just consider ways to really raise that question with your landlord. A lease can be really, really customized. It's never going to be perfection when we don't know what the future holds, but at least where the parties have turned their minds to what would be important in a shutdown, hopefully there'll be some really practical and helpful relief for both parties if we do experience a second wave of COVID-19 or another similar pandemic. So I think that's really, really important. I also think it will be important to demonstrate just goodwill throughout the whole negotiation process. I think if this taught us anything, this whole experience is that communication really is key between landlords and tenants, and keeping those lines of communication open is really essential. From a small tenant's perspective, I suspect that landlords will be looking for more personal indemnity agreements. So for example, if you've incorporated because you've spoken with your accountant or your lawyer and they've said it's right for you, and you've now moved yourself away from that risk and you've tried to sort of create a separate entity with your corporation, but if you're approaching a landlord and want to enter into a lease agreement, that landlord may say, absolutely happy to have you as a commercial tenant, but I'd really love you as an individual to sign as a guarantee or an indemnitor, so that I know that if your business is not doing well and it can't pay rent, I know that you as an individual have the obligation to pay the rent. And I think we'll see more of this, because what has happened is where there are more mature tenants, and corporations that weren't able to pay rent. Sometimes landlords were seeing that the individual who ran the business was still doing quite well on their own. And I think that is something that's so important, of course, to be able to separate the individual from the business. But ultimately, I do think that landlords will be seeking that additional security when they are signing up lease agreements with new tenants, especially where they don't have, where the new tenant doesn't have a long history of business, but perhaps there's some personal wealth backing the new business venture. Okay. Do we have any other questions, Mackenzie?
Yes, we do. We will get into them. We'll show my video here. So we can get to the first one here regarding retail and or office. What contractual lease provisions should be included to address the current/future pandemic? And where should those lease provisions live within the contract?
Okay, that's a really great question. Retail spaces it's such an interesting sector to consider in the context of what's happened, because retail spaces that are located in malls were affected very early on, and there was very little flexibility for them to reopen until the government allowed it, just by virtue of being a public space where it's difficult to socially distance and where there are specific entry points. Unless you were a tenant in a mall on an external wall and you had your own door, ingress egress access, then it was really difficult to sort of get creative with how you offered services to your customers and clientele. So I do think that for a tenant operating a retail or an office space, I truly believe that this will impact the value of spaces that have an external doorway, because it does provide you with more flexibility if you're not relying on common hallways as access points, not only from the perspective of being able to offer services to your clientele and customers, but also in terms of being able to ensure that your staff and employees are safe, and that you as an employer are reducing your liability and risk if you're asking people to come back and work. So I think location, it's so funny, right? The first rule of real estate is always location, location, location. And I think that's the first thing to consider. So if you have to pivot and change your service model, can I do it in this location? If you decide that you're willing or that you want to be in a mall, there's so many advantages to being in a mall. It might be worth seeing what provisions they're offering post-pandemic, post-COVID, or what provisions that they've changed to provide some relief to tenants in anticipation of a coming second, third wave, or a different pandemic altogether. Perhaps that is something that says if ever the mall has to close down its public entrance points, or there is a declaration that maybe there is a reduction in rent, or at least maybe there's a reduction in base rent, if not the ongoing operating costs. So typically with mall leases, there'll be a base rent, and then there may either be a percentage rent where you pay a percentage of your revenue. That hasn't been a terribly popular rent calculation method in the last decade, maybe 2 decades. But maybe that would make a comeback. It's so much more involved. The tenant has to give access to its financial records to the landlord in order to calculate rent. So you can see why it was unpopular. But maybe that is a really practical solution for certain tenant-landlord relationships. If the tenant's doing well, the landlord's doing really well with rent. But if there's a shutdown and the tenant's revenues fall, so too does their rent. So those are certain things that you can think about. Again, just making sure that your use provision isn't too tied to the method of delivering services to your client. So making sure that you can do takeaway food, and that's built right into your lease agreement, I think is terribly important. And then for office spaces, the one that I would tend to think about is if there are restrictions in the hours in which you can operate, that might be something that you would want to consider as an office, because as people are working remotely, or as you're hoping to space out your employees to different perhaps shifts where you haven't in the past, you would certainly not want any restrictions in the lease that prevent you from doing that. I think those would be the main provisions that I would look to, but it would be situation specific to the type of business you're operating.
Perfect. Great answer. And another question here, given the potential for additional flare-ups, so I guess second waves, etc., why should we provide additional free rent, etc., to sweeten the deal?
Right. Okay. So I'm thinking this is definitely a question from the landlord perspective. And I think that this is so on the money. And this is where we're getting into that tension between tenants and landlords, because there is a risk and the landlords can't shoulder the whole of the risk. So I truly don't believe that there's going to be a landlord who would put in a provision that says, hey, if there's a shutdown, don't worry about it. You don't have to pay me rent. Landlords have expenses associated with their buildings. So I don't know why they should have to offer additional free rent, other than if they've got a really good tenant and they know that they can't find another tenant, they might still want that good tenant when things do return to normal. So diminished cash flow over a short period of time is often better than no cash flow over a longer period of time where you've got to refixture the premises. I think in the fall, we will start to understand truly what's happened to the commercial leasing landscape. Barrie, where I live and where I work, has enjoyed a very strong commercial rent market for landlords in the last decade. It's where Sandbox Center is located as well. There's a fairly low vacancy rate for especially industrial space. But actually, I think this would be a great topic for Sandbox to explore with a commercial broker come fall, because I think that's where we'll see if it is worth landlords offering additional free rent. Because if it's bird in the hand is worth two in the bush, then maybe a really good tenant that you know paid rent as much as they possibly could is worth keeping. So that, I think that's the best I can do to answer that question.
Awesome. And I love that analogy. It was really, really funny. So another question here, will there be any legal concessions / considerations given to businesses who wish to break a lease due to the financial impact of COVID-19? I guess they're saying a lease negotiated prior to the pandemic and not yet full term.
Gotcha. So this is another good question. I would suggest that there is not going to be a ton of forgiveness. As I mentioned at the beginning of the presentation, commercial leasing, the way courts view commercial leases is as a contract that's entered into between two commercially sophisticated parties. So notwithstanding that very few people could have foreseen the COVID-19 outbreak, I think courts will be loath to say that a tenant got an automatic out because something strange happened. That's where we're sort of waiting, honestly, still to see what a court will do with that force majeure interpretation. And force majeure just means there's something that's so completely unexpected that the parties were prevented from providing the service that they promised they would. And so, for example, where a landlord just promises quiet access and quiet enjoyment of a premises, well, were they able to do that? So when you're thinking about a mall, I'm not sure. I'm not sure if a tenant could argue that a landlord was rendered unable to do that, or maybe that's their counter argument. And then the landlord ends up being the one that has to argue, well, I couldn't provide quiet enjoyment. And maybe they need to take a look at what quiet enjoyment even means. Does it just mean that the owner of the business can walk in and enjoy the space? Or in the context of a commercial lease agreement, does it mean that they have to be able to conduct their business for the use that the landlord's consented to? I tend to think that the courts will not take that liberal interpretation approach. And I tend to think that they will say, unfortunately, you signed your name to this piece of paper, knowing that your business might fail for any number of reasons. And unfortunately, you weren't able to make rent. And the landlord wasn't able to mitigate because there was a downturn in the economy. Perhaps, we don't know that yet. But I don't think that a court is likely to let a tenant off easily without a really good legal argument being made. So I would suggest that I think where we would see a lot of those legal arguments coming from are some of the larger shopping centers, and maybe some of the tenants that are chain tenants for whom the legal cost of taking this kind of argument to court might be worth their while if they've got multiple locations across the country. So where a landlord has applied for the CECRA benefit, where they were really helpful and really communicative with the tenant, I really don't think that a court is going to cut tenants too much of a break. If the landlord showed no signs of conceding anything and the tenant was actively trying to get them to apply for CACRA, I think that a court might be more willing to be a bit more lenient with the tenant, particularly as the government has demonstrated that it wants landlords and tenants to work together and to share the loss that has occurred. Okay.
Perfect. Next question says, my lease just expired. Don't know if I want to re-sign or for the length of term. What should I consider when reviewing my lease agreement and perhaps wanting to renew?
Yeah, so I think that's a situation where you've identified the provision that you have to consider, which is going to be the term and the ongoing renewal rights. So most commercial leases are 5-10-year term with additional 5 or 10-year term periods. Some are 1, 2, or 3 years. And maybe in this circumstance, that is where the tenant wants to approach the landlord to say, I'm willing to renew, but I'd really like to renew for just an additional 6 months right now, but I'd like the option to renew at whatever rent for a year or 2 beyond that. And that's where it really is going to depend if the landlord feels optimistic about whether or not they can find a new tenant. It takes time to find a new tenant. So typically, I don't want to speak for all landlords, but typically landlords would be willing to keep an existing tenant in for a short period of time, a stub period, if you will, six months, a year, to allow them to ramp up a search for a new tenant. So certainly I would say the term and the renewal provisions are what that individual is going to most want to consider.
Okay. The next question is about negotiating lease rate and conditions. Any tips or tricks you might have in negotiating a lease term? The person says, I'm in the market to lease a space, but my business is new, so I'd like to mitigate my risk as much as possible.
Okay, so tips and tricks for negotiating leases and rates. I always think that you need to know what's most important, and this really isn't a tip or a trick, but know what is most important to you about the lease, whether that's certainty of rent, in which case maybe you're not thrilled about a lease that's structured to have base rent plus additional rent, or maybe you're looking for the landlord to cap that additional rent for the first year if you're a new business. And a lot of landlords will balk at that, but if it's a landlord that's had the premises for a number of years, they might feel really comfortable knowing that their operating costs are really unlikely to increase over a certain percentage. So they may actually agree to a ceiling for additional rent for a year or 2. Some would absolutely not be willing to do that, but there are some that will. So that's something to kind of consider. The other things, this isn't so much a tip or a trick, but often where tenancy relationships start out really, really well, and then something happens and everyone starts pouring through the lease to try and find a loophole or an out, the smallest details tend to be the ones that trip people up. So make sure there's a really clear diagram of what the premises actually is, your space plus any space that you have the right to access. This should include things like access to shipping doors, receiving doors, common areas. It should be really clear about whether the landlord is allowed to lock the door to the common hallway at 5 p.m. if they've said, oh yeah, but you can operate until 8 p.m. It should also include things like parking spaces. So if parking is super important to you, make sure it's built into the lease. I also always think, and this is, most leases have this, hands down, but where your rent is a per square foot figure, make sure you've agreed to that actual square footage in the lease. Sometimes people don't do that, or sometimes the language will just have a picture of the premises with the square footage that everyone thinks it is written in. That's really, really difficult to enforce later on. So things like that, just, so not so much tips or tricks, but know what's important and just make sure that the lease is super clear. And it does get hard when they get into the 30, 40, 50 pages mark. But yeah, just really focus on knowing what the landlord can charge you and what those figures can be based on. and then make sure that you have gone through in your mind what your business operation looks like, what it might have to look like, and make sure that that is built into the use provision.
Awesome. I think those were great tips and tricks.
Oh, thank you.
Next question. There doesn't seem to be a lot of shorter term, mainly 6 month to a year leases out there. If I have to sign a longer lease, how do I protect myself in case my business doesn't work out?
So so we will see, I think, I could be wrong, another sandbox topic, commercial broker coming in and talking about the real estate market in the fall. We could see some landlords that start to offer shorter term leases, or they might be willing to offer an initial 6 months with an option to renew. The best way to protect yourself with a new business is just to make sure that you are not personally signing that lease. So if you have to sign a 5 or a 10-year lease, number one, make sure that you have the right to sublet and that the landlord cannot unreasonably refuse, so that at least if you're not using the space, you can bring somebody else in who can at least pay part of the rent. It's really difficult to do that, though, if the whole point of doing that is because you don't think the landlord can find another tenant. So honestly, the cleanest, simplest way is just don't sign the lease personally. Make sure it's your corporation that's signing, and a corporation is different than just a business name. So make sure that there's that distinction, and then don't sign as an indemnifier. Now, as I'm saying this, I'm sure we've got an audience of tenants and landlords, but from a tenant's perspective, you don't want to sign as an indemnifier because that's you personally saying that you'll pay the rent even if your business goes away.
Next, how does a tenant ensure that the landlord has gone through the proper governmental channels / permits or proper construction? Leaseholds are often done before a tenant takes possession. Recognizing having the tenant request proof may set a sour tone, which is not a great way to start a new relationship.
Yes, yeah, no, totally understandable. So I do think it depends a little bit on the fixtures themselves. So there's a couple of different things that you can do. So one, at the outset of the contract, if you're a tenant who's fairly savvy and who has access to good trades that you trust, one thing that you might actually do is ask the landlord for the ability for you to control the actual fixturing process, but then have the landlord reimburse you up to a certain amount, that would be the tenant allowance, for the cost of putting those fixtures in. Often it makes more sense from an economic perspective to have the landlord do it, especially if they're redoing a whole building or a whole center at the same time. But that's one way. So tenant controls the actual construction, you know it's done properly, and then the landlord advances money or provides you with free rent as compensation. The other way, though, if it's a slightly smaller space or if it's a more structural improvement or fixturing that you're hoping to really make sure was done correctly, it is the building inspection reports. And so maybe that's something that you put into the provisions in the lease under the landlord's work, is just something to the effect of, one, that the landlord's providing you with the specifications that their subcontractors will be following. Typically it's the tenant providing those specs anyway, so you should have your own architect or your own contractor go through afterwards and make sure everything's done appropriately. But otherwise you could put a provision into the lease that says, we want to see the building inspection reports. That's obviously going to be for more structural things. It won't necessarily tell you that they put in the exact HVAC system that you wanted. You're physically going to have to take a look or hire someone to do that for you. So detail in the specifications as to what the landlord's agreed to do, and then your own inspection or with a trusted tradesperson is probably the best route.
Now we have somebody asking in regards to evictions. The tenant pays 25% for the 3 months, April, May, June, has not paid anything else. Can tenant be evicted, and when?
So June 30th, the government just announced that the CECRA benefits have been extended over the month of July. So for this landlord, you should still be getting the 25% from the provincial and the federal government. So 50% total. But yes, so we are at the point that they've entered into the CACRA agreement. The landlords have agreed not to evict the tenant for a certain amount of time. So it should be the end of July that you can start giving notice, but I would start sending notices to the tenant now. And then depending on when they paid their rent, typically it's the first of the month. I'm guessing that in this case it is as well, because we're at the 16th. So it was either the first or mid-month where they didn't pay. If you've got any deposits, apply the deposits certainly against the arrears that are now owing. But no, it's a good question as to when you can start to enforce. And if you have entered into that CACRA agreement, right now you're not supposed to be enforcing. But if the tenant has breached and hasn't even paid the 25%, then you can start to take steps to enforce. But do know that there's a moratorium right now on any evictions or any seizure of assets. So I would start with the notice, and then I would get legal counsel to review your specific lease to see what other rights of enforcement you might have built in there. I suspect you're going to have to wait at least until the end of July before you can take any really aggressive action to enforce. But again, get specific advice.
Yes. I think just on that topic, somebody just asked a quick question before I get to the last two here that we have. Can a landlord still apply for CECRA? I don't want to mess that up. Relief,
right.
Even for April to May, up to the end of July.
Yes, you can. And I'm just going to do a quick search because you can apply. And I'm just trying to see how far back you can go retroactively. So the July extension option is, and you can actually opt in for just July now. If you hadn't previously applied, you can certainly opt in. And I'm just trying to see here how far back you can go. I know that you could apply retroactively in June to go back to May. And I apologize. If we get the contact information for that person, I will give them the date to which they can apply retroactively. But certainly you can apply backwards. And if you hadn't applied before, you can now apply for just July. And I will get the exact dates for that individual.
Okay, no problem. If you want those dates, you can send your information to info@sandboxcenter.com, and we'll be sure to share that information with you, because this it does say anonymous at the moment, so I can't see who the contact is. But, next question is, if a landlord declines applying for CECRA because they believe a tenant needs to own up to their obligation, would you advise to try to reach a mutual agreement if possible? Alternatively, would the Protecting Small Business Act help here and where?
Right. Okay, so there's a couple of questions in there. If the landlord just is saying to the tenant, listen, this is what you agreed to, this is what needs to happen, but I'm willing to do X, and the tenant's willing to do that, I absolutely think that that's a great way to proceed. I think anything where the parties work together and come to a mutual alternative understanding is going to beat anything else, whether it be CACRA, where ultimately the landlord loses the right to 25% of the rent. But I do think it is important, if the landlord is not applying for the CACRA, to know that they can't take active steps right now to enforce their lease. So you can't distrain, you can't go in, you can't seize assets, you can't lock the door, you can't do any of that. And that's because of the Protecting Small Business Act. So basically what the Protecting Small Business Act has done is said any steps from May 1st going forward. So keep in mind, this was an act that took effect June 18th. And the government felt so strongly about landlords trying to enforce commercial leases that they actually said, not only can you not enforce the lease going forward if you haven't applied for the CECRA benefit, but if you had already taken steps to enforce, if you had seized assets, you have to return those assets, or you have to return the money that you got for those assets to the tenant, and you might owe them compensation for the difference of what it costs them to outfit their space. So where you are a landlord who is hesitant to apply for CECRA, I do think that coming to an agreement with a tenant is your best bet, whether that's trying to defer rent but do know that if the tenant just sticks to their guns and then we get through this period of time and eventually Protecting Small Business Act is no longer applicable, then you could take steps to enforce, but the court's always going to know that that period of time was supposed to be protected. So likely the tenant will hopefully be paying you back for rent arrears. Maybe you're offering them a low interest rate on a promissory note. I'm not sure what the agreement you'd be looking to strike is, but know that the alternative agreement should be very, very reasonable if a landlord is refusing to apply for CRA.
And we have our last question here, which is awesome because we're coming up to the end of the hour. So they are saying, how do the courts treat what may be reasonably assumed in the lease versus what actually is written? For example, this person read a lease that read that an element of default would be considered if the space was vacant for 30 days. There are 52 Sundays in a year, so if the tenant doesn't operate on Sundays, they are technically in default. Was it meant to be consecutive 30 days? Maybe, but if a landlord wanted the tenant out, is this a reasonable argument?
So I love this question. This is almost like a textbook law school question. So it absolutely should have read 30 consecutive days. I think just from a practical perspective, I think we can all agree that that's likely what was intended. So because we're a common law, the courts look to a few different factors when they're trying to figure out what the interpretation should be. So common law just means they consider all past cases at the same level of court or higher, and they look to see how those kinds of provisions had been interpreted in the past. I think that specific provision, if it has ever been tried, and it would be interesting to know if someone went to court and made that argument, I think it likely that it would be clear that the parties intended it to be 30 consecutive days. I think the court would look to past behavior of the landlord and tenant. So for example, if this lease has been in effect for more than a year, if you're in the second or third year of your lease and the landlord never raised Sundays, the premises being closed, as a concern before, the court would certainly look to that and think, well, they knew it was closed on Sundays. They never tried to enforce on these grounds before, probably not what they intended. It will also, there's a principle called contra proferentum, which means that the document is interpreted against the person who drafted it. Usually it's the landlord that has a standard form of lease. So if the landlord put forward this lease agreement and there wasn't a lot of back and forth and no one kind of tinkered with that specific provision, I think the court is more likely to find against the landlord's interpretation, especially in this case where I think it's, I shouldn't speak out of turn, I wasn't there, but I would suggest that that particular provision was intended to be 30 consecutive days, and that unless the landlord can show reasons that they viewed it as otherwise, it would be a bit of an uphill battle for them.